Officer Dave, would you open the courtroom for us, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning.
Hello, good afternoon, Your Honor.
Good morning.
Good morning, Your Honor.
We are on the record. This is 22-178-350. Timothy Jacobitz versus Wade Prime Properties, Center Management LLC. This appears to be our initial pretrial. Your respective appearances, please.
Thank you, Your Honor. Sean Riddell, P81302, appearing on behalf of plaintiff Timothy Jacobic.
Good morning, Your Honor. Issa Haddad, P71699, on behalf of both defendants.
All right, gentlemen, how's our written discovery coming? It's been open for more than a month.
So we
Your
sent
Honor.
off the discovery. I'm sorry, go ahead, Sean.
Yep, I sent out a first round of discovery requests yesterday.
Okay, and Mr. Haddad, you sent yours out earlier?
Yeah, I sent mine out earlier. I don't have the exact date in front of me of when I sent that out.
Let's get them rolling, gentlemen. What are you asking for, Mr. Riddell?
Essentially, I'm sorry, I missed that last part.
Mountain controversy. That's really all I'm interested in, making sure.
Sure. I'd have to look at the complaint, but I believe that the damages were somewhere around 8,000, and then there's attorney fees under the Michigan Consumer Protection Act.
Well, we'll get to that.
Mm-hmm.
Are you having any problems at this point? Well, I guess it's really early to see whether you're having any problems with discovery because you're just getting started. So let's do this. Let's continue your written discovery. Let's get your return date and get you on your way.
Your Honor, can I just ask two questions? Sure. The first one is, Issa, I haven't received the written discovery yet. Can you email those to me, including Word documents?
You have, I'm sorry, you haven't received my discovery that I sent off?
I haven't.
Okay, I will resend those off, and I'll resend those off in Word.
Okay, thank you. And then, Your Honor, I filed a motion for summary disposition yesterday. I would just ask that the next pretrial also include a hearing date for that.
I'm not going to do that. What's your motion based on? C10?
Oh, it's a C8 motion on defendant's counterclaim for conversion.
Well, let's see where we are. He hasn't, if you filed it, he by definition hasn't had a chance to review it.
Correct.
So first of all, did you call him and ask him for his agreement to dismiss the conversion claim?
I did not, Your Honor.
What does the court rule require? Before you file a motion, you seek concurrence.
Okay.
Let's follow the rules, gentlemen. We're lawyers, for God's sake. They're supposed to mean something to us, if nobody else.
Understood, Your Honor.
We'll talk to you gentlemen again, August 25th at 10 o'clock. Anything else we can accomplish today?
Your Honor, I have an out-of-town event.
That doesn't work for you?
Is September 1st available? The following Thursday?
Let me see. Let me get the magic box out here. Counsel, does that work for you?
I'm looking now. It does, Your Honor.
All right, September 1st, gentlemen.
Thank you, Judge.
1st, and we're going to see you at 10 o'clock. Thank you both for coming.
Perfect.
Have a nice day. Bye-bye.
All right, you too.
Okay, that might be it. Good morning, council.
Good morning, Your Honor.
What file are you here on today?
This is Capital One versus Richard Stafford.
Okay. See if I can get the other guy to connect. We can get started.
All right.
Seems to have some trouble connecting to audio. There he is.
I apologize, Your Honor. I got sidetracked.
Okay, let's call your case and let's get started.
Okay.
This is file number 22179-724. Capital One Bank versus Richard Stafford. Date and time for what appears to be our first pretrial. Your respective appearances.
Thank you. Good morning, Your Honor. Daniel Best, P58501 on behalf of Plaintiff Capital One Bank.
And Andrew Hendra, P82429 on behalf of Richard Stafford.
Okay, how are we coming, gentlemen, on our written discovery?
I don't believe that either party has issued. There has been some settlement discussions, but we still
didn't settle.
remain relatively far apart.
But you didn't settle.
But we did not. That is correct, Your Honor.
So then let me ask again, what's happening on our written discovery since we're not settling?
Your Honor, and I'm not sure how this happened. The order allowing for written discovery was actually sent to my client, who didn't give it to, and the notice of the appearance for today's was sent to my client. I received it yesterday. So I do believe that we'll be able to settle this. It was really odd. It had to get sent to me and he didn't know I didn't receive a copy.
All right, so that's a screw up on my end, apparently. So we'll give you guys another date. And Mr. Best, what's the amount of your claim here?
Your Honor, we're seeking $6,483.94.
Unfortunately, gentlemen, we're on Zoom. If we were live, I'd invite you up to the bench, head in one hand, head in other hand, bang heads together, settle cases. But we can't do that on Zoom. So I have to give you another Zoom date. Does August 25, does that work for everybody?
Yes, Your Honor.
How about-
Yes, Your Honor.
Okay, August 25 at 10 o'clock. We'll continue your written discovery. Is there anything else we can accomplish today?
No, I think we'll bang this one out. I don't think we'll see you again.
Okay, then we'll send you guys out an order today. Thank you both for coming in and let's be safe.
Great. Thank you. You
Thank
too,
you very
Your
much.
Honor.
Have a good day.
You too.
Counsel,
Good morning, Your Honor.
good morning. Who are you representing today, sir?
Credit Acceptance Corporation.
Okay, you're here for Rusin?
Yes.
I do not have an opponent for you as of yet, so I'll put you back in the waiting room.
Thank you, Your Honor.
Mr. Nate, good morning.
Good morning, Your Honor. How are you doing?
Good. How about yourself?
I'm okay.
Citibank versus Wade Mitchell?
Good morning, Your Honor. President Nate, P
Yeah,
77884.
I don't have your opponent as of yet.
Gotcha.
I'll let you know that I know you're here. I'll put you
Okay.
back in the waiting room. I have two lawyers and I have no defendants.
I'm happy to wait.
Maybe I'll put you guys together, make one case, at least settle that one.
Sure.
I'll get back to you as soon as I can.
Sounds-
Thank you. All right, let's turn the music back on. Let's turn this off. I need to. What is your name, sir?
My name is Andrew Cates.
Not you, no.
I'm sorry, what was that, Your Honor?
I'm looking for the other person.
Joel Montgomery.
Mr. Montgomery, this matter was set at 10 o'clock. I was about to default you.
No, I'm sorry.
Let's get started. We are on the record calling file number 22-187694, credit acceptance versus Gerald Montgomery, date and time for pretrial, your appearances.
Good morning, Your Honor. Andrew Cates, P78292, standing in for the attorney of record and representing Credit Acceptance Corporation.
What is your name, sir?
Jarrell Montgomery.
Is it your intention to represent yourself in this matter?
At this point, yes.
You have an absolute constitutional right to do that. What you do not have is a right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that bind that attorney will bind you. Do you understand that? Sir, do you understand the things I've said to you?
Yes. I'm sorry. I thought you heard me. Yes.
All right, I'm not spending any more time here. What I'm going to do is I'm going to open your written discovery, and I'm going to give you gentlemen a return date. Your return date with me will be August 25 at 10 o'clock. Does that work for everybody?
Yes.
Yes, Your Honor.
Okay, anything else we can accomplish today?
No, Your Honor, that'll do. Thank you.
Anything for you, sir?
No, thank you, sir.
August 25, 10 o'clock. Your written discovery is now open. Thank you both for coming in. We are off the record.
Thank
We are on the record. This is file number 22185-681, Citibank versus Wade Mitchell. By a notice dated June 7th, 2022, sent to the parties on that date. This matter set for pretrial today, July 7th at 10 o'clock. It's now after 10:30. Could I have your appearance, please?
Preston Nate, P77884, appearing for Citibank.
Plaintiff has appeared, defendant has failed to appear. No good cause of that failure having been shown. The default of the defendant is hereby entered. Mr. Nate, we look forward to your motion for default judgment. Thank you, sir, for coming in, and let's be safe out there.
You're welcome. Appreciate it, Your Honor. Thank you.
All right, have a good day.
You too.
Thank you, sir. Ms. Ellison? Mr. Carpenter?
Good morning, Your Honor.
I have one more person here, I presume is your client. Let's see if we can get her in here. All right. That is your client, Mr. Carpenter, Luella Bass, correct?
Yes, I am.
Correct, Your Honor. Yes,
I'm
Your
going to
Honor.
put her on mute. I'm going to call your case and we're going to get started. We are on the record. We are calling file number 21240-852. Luella Bass versus Go-To Guy Property. There's a counterclaim by Go-To Guy against Luella Bass. Your respective appearances.
Good morning, Your Honor. Corey Carpenter, P67818 on behalf of Ms. Bass.
Good morning, Your Honor. Attorney Elizabeth Ellison, P82098 for the defendant Go-To Guy.
All right, my review of the file indicates that by an order dated dated June 6, 2022, which memorialized the court's decision of April 21, 2022, plaintiff Luella Bass's claims had been disposed of. The only matter before us today is a motion for summary disposition filed on behalf of counter plaintiffs, two guys. We got after our last meeting, I got Ms. Ellison's counter plaintiff supplemental brief in support of motion for summary disposition, which had not been reached the court file as of then. Ms. Ellison, your motion.
Your Honor, we were here previously and we started arguing the MSD, so I'm just going to give a brief overview of that and then go into my supplement. The notice to quit was served on June 16, 2021 regarding my client Go-To Guy no longer wishing to rent to Ms. Bass following the termination of her lease on October 31st, 2022. They served her that early because she is a Section 8 tenant and they know it can be hard to find Section 8 property.
Oh, wait a minute, wasn't that leased to vacate by October 31st, 2021?
Yeah, the move out day was October 31st, 2021, because that's when the lease.
Yeah, you said 22.
I apologize.
Move on.
Ms. Bass chose not to move out by November 1st, and my client filed an eviction action. At that time, my client was granted possession of the property with the move out date of April 7th, 2021 or 2022. Ms. Bass moved out on April 8th, and we're requesting rent from November 1st to March 30th in the amount of $3,875, Your Honor. When we were previously.
What's the monthly rate on that?
The monthly rate, Your Honor, I do believe is $775. Let me just verify that.
It's $771 from DHS.
And then
Housing Commission and 4 from the tenant.
Correct. Yes, $775, Your Honor.
Got it. Moving on.
When we were previously here, Mrs. Bass' counsel argued that we were not entitled to rent due to abatement. However, that is not true, Your Honor, which is why you ordered supplemental briefs for us to provide evidence of that. My client ended their HAP contract on November 1st as they no longer wished to rent. So they were no longer in the HAP program at that point in time for Section 8, Your Honor. So the general contract principles would control. She signed a contract for rental rate of $775. She chose not to rent when she chose not to move out. So therefore she would be entitled to the entire rent because the HAP contract had been canceled. We told them 6/16/2021 that we wanted it canceled as effective October 31st. Furthermore, her counsel argued that it was an abatement, so we were not able to collect rent. However, in my supplemental brief, Your Honor, the abatement notice is clear. The abatement notice says if she chose to stay longer than the amount, then she would be, it says, if the repairs are not made within 60 days of the abatement, this letter serves as notice that the HAP contract would be terminated by DHC. However, it further goes on to say that if the owner decides against making repairs and you remain in the unit for 60 days after the start date of the abatement, you may lose your housing choice voucher and you will be responsible for the entire contract rent listed on the front of this letter, which the front of the letter said that it was $775. The HAP contract end date was 12/30/2021. However, my client did not fail the inspection, Your Honor. Ms. Bass was not present for the inspection. I've included all of the work orders where it was a door issue. I included all of the, I included the invoice where my client did indeed repair the door issue in plenty of time. And then I also sent you the letter from the HAP that said that no one was present the day of the inspection. It's the tenant's responsibility to be present the day of the inspection. Therefore, Your Honor, my client is entitled to the rent.
Let me hear from Mr. Carpenter.
Thank you, Your Honor. First of all, I just want to place on the record the fact that the June 6th order that Your Honor referenced at the beginning of the hearing, I never received in the mail. Luckily, I checked the court's docket. I checked it actually on the 7th because I had been out of town and realized that it was entered. I had to get a copy of it from Miss Ellison. So I just want to make that perfectly clear that although the court docket says it was mailed out to the parties, I never received it. For whatever reason, I never received it. I just wanted to place that on the record, Your Honor.
Thank you, sir. We'll continue with your argument.
Thank you. Your Honor, I don't think there's any dispute that the property was in fact in abatement. Regardless of Ms. Bass being there or not being there, and of course, that's the counter plaintiff's argument. According to Ms. Bass' affidavit, sworn affidavit under oath, the repairs weren't fully completed until March, about a month before she moved out. That's, I mean, her affidavit speaks for itself. Nothing else. I think there's an issue of fact as to that. And even by Miss Ellison's argument, at worst case, she would only be on the hook for rent from January through March. At very worst, and we're not conceding that. I'm just saying and at worst, that's what she would be on the hook for, 3 months of rent, less the $4 that she had prepaid through March that plaintiff failed to keep and refunded to my client. And I just also want to address, the counter plaintiff's argument that Miss Bass chose to stay in the property. That's simply not true. With a Section 8 tenant as she is and her limited resources, it's a matter of being able to find a place that will accept her. She moved out April 8th and was living in her car for about 6 weeks before she finally found another place. So I think that belies the argument that she somehow said, I'm just going to stay in this property as long as I can, no matter what. She moved out when the court ordered her to move out by, and she was living in her car until she'd find a suitable. So it wasn't a matter of her taking advantage of the fact that she was holding over as long as she could. I was in contact with Ms. Bass from January through April, constantly following up with her, seeing where she was as far as getting new housing. And, finally she was able to get some, I think the beginning of the first or second week of June. So she was living out of her car for 6 weeks, Your Honor. So I just want to make that perfectly clear for the record.
Anything else, Mr. Carpenter?
No, Your Honor.
Ms. Ellison?
Your Honor, I want to be very clear. My Exhibit 7 from the Detroit Housing Commission specifically says the unit has passed our inspection and meets all of our housing quality standards. Please review the following notes from our inspection. Comment: tenant not satisfied of the job, but took pick to verify. New fail items: unit entry door hard to close / lock inside main door deadbolt not locking. That is the exact issue on September the 10th, 2021, that put that the Housing Commission passed the inspection, Your Honor. Now she's complaining about a failed lock issue. So then my Exhibit 8 literally says we were unable to conduct or complete the inspection on 10/8/21 to ensure the unit meets the quality standards because no show, no answer at 12 p.m. Unit entry door hard, and then it goes into saying what the issue was. Your Honor, I also provided an invoice dated September 29th, 2021 that shows that my client had went out there, paid a maintenance man $300 to fix the property, which was well within the abatement period, Your Honor.
I'm prepared to rule.
Your Honor, may I?
Yes, sir, Mr. Carpenter.
May I make a brief comment in response to that?
Sir, please.
Thank you. One, it's just an invoice. There's not an affidavit from the contractor saying that the work was actually done. It's an unverified invoice. My client's affidavit indicates the door was not fixed satisfactorily until March. She also indicated that there were a number of other problems with the unit. One, which I attached pictures to in a prior pleading, that being the leak in the bathroom that was not fixed. There's no evidence that was ever fixed satisfactory. And there was also a rodent problem in the unit, which I think there is cause for potential offset of rents owed. So just wanted to place that and make the record complete, Your Honor.
Thank you. The court is prepared to rule, and I want to thank you both for your voluminous pleadings in this matter. It's clear to the court that the motion for summary disposition on behalf of the defendants, which is the matter before me today, should be granted. Defendants Exhibit number 3 demonstrates that there was a notice to quit served on the Ms. Bass on about June 16th, 2021, with a vacate date of October 31, 2021. That was the end of the lease period, which had commenced on October 2nd, 2020. The Exhibit 4, which is dated 10/8/21, says that the period of abatement is to begin 11/1/21. However, in that interim between the 11/1/21 date of abatement, we have the Detroit Housing Commission letter dated 5/26/22, which says that there was an inspection done on September 10th, 2021, which is prior to the move-out date. And it says that the unit has passed the inspection. So the court finds that the unit was habitable as of the 10/31 date that the defendant, counter-defendant, was to move out. It is uncontroverted that Ms. Bass did not vacate the property for whatever reason at that October 31st date. She was in the property from until sometime in April. And the good guys is seeking rent for the months of November, December, January now over in 2022, February 22, and March. Court finds that they are entitled to rent $775. That was the $771 plus the $4 paid by the tenant for that period of time. And getting my calculations calculator out here, 775 times 5 is $3,875 minus the $4 credit Ms. Bass is entitled to for the money that was sent in. The court will enter judgment in favor of the counter plaintiff in the amount of $3,871 plus costs and the statutory attorney fee. There's
Your Honor, with the $4,
excuse me, I'm sorry, Mr. Corporal, go ahead.
with the $4 credit, it was $4 per month.
$4
That was her
per
rental
month.
allowance.
All right, so that would be then, instead of $38.75, 1, 2, 3, 4, 5, that would be $20 credit, excuse me. That would be $38.55. $38.55 is the judgment in favor of counter plaintiff good guys, plus costs and statutory attorney fee. Ms. Bass vehemently is objecting, and she's raising her hand, and she's been, how to say this, clearly speaking, but since she has counsel, I have muted her, and she has an absolute right to appeal. And appeal must be perfected within 21 days of today in the Wayne County Circuit Court. Ms. Ellison, I look forward to your order. Thank you all for coming in, and thank you all for your briefing. We are off the record.
Thank you, Your Honor.